Namaskar, my friends. So long we have discussed various aspects of human rights, and today we are going to discuss the socio-economic developments and the human rights. The problem of individual rights and freedoms and of the relations between individual on one hand and society and the state on the other is among the oldest and the most complex ones in the human history, both in terms of theory and practice. Since the year 1950, if not earlier, there has been a list of the human rights in India guaranteed under Part 3 of the Constitution. These rights are enumerated human rights of India and are sacrosanct, basic and inviolable, that state cannot make any law which may abridge any of these rights, and besides that, all pre-constitutional laws shall stand to be void if such laws are found to be in contravention of any of these rights in Part 3. While there is a wishful expectation of the people to the authorities not to encroach upon the human rights, a socio-economic change would certainly claim, restrict, or even extinguish human rights. So, this discussion shall be carried out regarding the change in contents and the form of the human rights due to socio-economic developments happening around us. For this purpose, reference shall be made to the Constitution and ordinary laws, various constitutional amendments with the views of the Supreme Court of India. The constitutional mechanism and the socio-economic development. In this aspect, the Indian Constitution was drafted and prepared in the mid-20th century, which is an era when the concept of social welfare state is predominant. The concept of welfare state is strengthened by the directive principles of state policy, which set out the economic, social, and political goals of the Indian constitutional system. Article 38 envisages socio-economic justice, that state is to strive to promote welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. And Article 39 lays stress upon certain aspects of economic justice. Article 39B and C are very significant provisions as they affect the entire economic system in India. Article 39B contemplates measures to secure equitable distribution of the community resources. Article 39C contemplates measures for preventing concentration of the wealth and means of production in a few private hands. Both the articles point mainly to one aspect amongst others, that is land acquisition, and to bring about agrarian reforms by abolition of Zamindari system. An example may be cited in the Bihar Land Reforms Act 1950, which was passed to abolish Zamindari system by fixing ceiling on land holding and grant allotment of such acquired land to landless persons. the matters relating to socio-economic development and the aspect of human rights in India after independence. No fundamental right has probably caused so much trouble as has given rise to so much litigations between the government and the citizens as the right to property enshrined in Article 31 till the right is repealed in the year 1978 by the 44th Amendment of the Indian Constitution. Now let us come to constitutional amendments. The courts in many cases lean towards protecting the property rights and payment of adequate compensation for property rights acquired by the state. The state, by making amendments of the Constitution, sought to fix the compensation at a sum lower than the market value of the property acquired. The state further sought to minimize intervention by the courts in this area. The 1st, 4th, 17th, 25th and 42nd Amendment Acts were brought about on the aspect of payment of compensation in acquisition of the property rights. The First Amendment 1951 introduced the 9th schedule of the Constitution. Any law which is placed in this schedule cannot be challenged on the ground of violation of Articles 14, 19 and 31. Thereafter, many laws have been placed in this 9th schedule. The further effect of these constitution amendments is that though the legislature was under a constitutional obligation to pay compensation, the adequacy of the same shall not be questioned before any court of law. A person is not allowed to challenge the validity of the law providing for acquisition of the private property on the ground that the legislature has not provided for payment of full value of the property. But the Supreme Court held that although adequacy of compensation cannot be examined, but still the word compensation would mean payment of market value of the property acquired. The 25th Amendment in the year 1971 had substituted the term compensation by the word amount. Article 31C was also inserted by providing that a law seeks to implement the directives in Article 39B and C, that is, the plan of socialistic distribution of wealth and means of production shall not be void for inconsistency of Articles 14, 19 and 31. Let us also discuss the concept of eminent domain and deprivation of the human rights by the state. Eminent domain is regarded as an inherent right of the state to take private property for public use. It is the superior domain over all properties within its boundaries that property acquired by its subjects is under the control and benefit of the public, irrespective of the wishes of the owner. Indian version of the eminent domain is contained in entry number 42 of list number 3 of 7th schedule of the Constitution, which enables both the Parliament and the state legislatures to make law relating to acquisitioning and requisitioning of the property. An incidence of the exercise of this power is that the property shall not be taken without just compensation, but in order to make the matter of compensation to be fixed below the market value, the provision of the fundamental right has been amended very often. Another issue has cropped up is as to whether the Parliament is competent to amend the Constitution so as to abridge the fundamental right in Part 3 until the noted case of Golaknath versus State of Punjab, AIR 1967, Supreme Court 1643. The Supreme Court has been holding that no part of the Constitution was unamendable, including the provisions of Part 3. The Parliament may, by passing a Constitutional Amendment Act, amend any provision of the Constitution, including the fundamental rights. But in Golaknath, a majority of the 6 judges in a special bench of 11 overruled the previous view and took the view that although there is no express provision in the Constitution, the fundamental right in Part 3 of the Constitution cannot by its very nature be subject to the process of amendment. And if any such right is to be amended, a new Constituent Assembly must be convened for making a new Constitution, for changing it. The Kesavananda Bharati versus State of Kerala, AIR 1973, Supreme Court 1461, which was heard by a full bench of 13 judges of the Supreme Court, has overruled the view of Golaknath. Thus, the settled view is that there is no fetter on the part of the Parliament to amend Part 3 by following the procedure for amendment under Article 368. The development in the post-Kesavananda is that the Parliament brought out the 44th Amendment of the Constitution in 1978, and the effect is that the fundamental rights to property enacted in Article 19, Clause 1, F and Article 31, Clause 1 are repealed and taken out of the Part 3. A separate Article 300A is inserted, which read as, "No person shall be deprived of his property save by an authority of law." The result of the amendment is that if an individual's property is taken away without legal authority or in excess of the power conferred by law in this behalf, he can no longer avail of the speedy remedy by going direct to the Supreme Court under Article 32, as Article 300A is not a fundamental right. He has to find his remedy from the High Court under Article 226 or by an ordinary suit. Now, the human rights to rehabilitation and resettlement in the event of land acquisition is another aspect which requires consideration in our purpose of study. The Parliament passed the Right to Fair Compensation and Transparency in the Land Acquisition, Rehabilitation and Resettlement Act 2013 as the first national law on the subject of resettlement and the rehabilitation of families affected and displaced as a result of land acquisition. Therefore, this new act is an important subject while considering the socio-economic development and the aspect of human rights to life, livelihood and comfort. The Land Acquisition Act 1894 was the law in force before passing of this new act. The old law was for acquiring private land for public purpose and also for establishment of companies. Multiple amendments have been made to the old law, but much less are provided which concern the farmers and those whose livelihood are dependent on land being acquired. There is also total absence in the old law for facilitating land acquisition for industrialization, infrastructure and urbanization. The new act makes provision for minimum compensation for the land acquired. A comprehensive compensation package is laid down in Schedule 1 of the act. As regards computation of the market value of the land, the minimum land value, if any, specified in the Indian Stamp Act 1899 for registration of the sale deeds in the area where the land is situated, or the average of the sale price for similar type of the land in the village or vicinity ascertained from 50% of the sale deeds registered during the preceding 5 years, where the higher price has been paid or whichever is higher. The market value so calculated shall be multiplied by 3 in the rural areas as regards buildings, trees, wells, crops, etc. The value is as per valuation by the government authorities. The total compensation is computed, taken the market value and the valuation of the building, etc. together. Besides this, a solatium of 10% of the total compensation is entitled to a person whose land has been acquired by the government. So now friends, we can conclude. India is a country where there exists a wide gap between haves and have-nots. In implementing the socialistic pattern of society as mandated by the Constitution, there is the requirement of narrowing down the gap, and this is one aspect of bringing about socio-economic change. The contents of the human rights in the matter of property have undergone changes by the process of amending the Constitution. The necessity for amendment was due to payment of compensation in the cases of acquisition of land of private persons for public purposes. The Land Acquisition Act 1894 was the old law which made to be enforced, became anti-people for the low value it placed on compensation. The passing of the new law known as Right to Fair Compensation and Transparency in the Land Acquisition, Rehabilitation and Resettlement Act 2013 has provided most enhanced compensation up to 4 times the highest sales value in rural areas and up to 2 times the value in urban areas. In addition to compensation, the law also provides for rehabilitation and resettlement of all families displaced by land acquisition. This includes those families which have been dependent upon land for livelihood purposes as well. The tenants, sharecroppers, and other groups which would have left defenseless under the old law have been taken care of under this new act. Considering the law as a matter of protection of the human rights regarding property acquisition, people are protected well than ever before. So with these few words, my friends, let us conclude. Have a good day.